At Denton Peterson, since we do a lot of franchising work, we also work a lot with FDDs, or franchise disclosure documents. Now, those can be frustrating for our franchisor clients. They take a lot of time, they take a lot of effort, and they can be just aggravating to have to deal with for clients who frankly would rather be out doing franchising and building their businesses. But I always tell my clients, look, you've got to do them under law. There's no way around it. And if you're going to have to do one, you might as well have it created in a way that's going to protect you as much as possible. So that's what we do with our clients. One of the things that's required in FDD is an audit. You've got to have audited financials, and you've got to make sure that they're attached as an exhibit to your FDD. One of the financials don't create issues by either being contradictory to something that's in the FDD or creating new obligations that you don't realize that you're assuming. So for example, as I talk to colleagues, we've discussed FDDs that we've seen where item 8, where it talks about required suppliers and required purchases from the franchisor, says that those aren't required, but then when you go back to the audited financials and to the notes, you see a reference that they are required, inconsistent, and obviously a problem. I've seen other situations where item 8 says that the franchisor does not get money from supplier rebates, but the financial statements reflect that they do get money from the supplier rebates. Another situation where item 11 said that the ad fund money would remain in the ad fund over, year over year, but that the notes to the audited financials say that in fact that money will be returned every year. And in other situations, we've even seen where the number of outlets listed in items 1 and 20 of the FDD are different than the number of outlets that are listed in the notes to the audited financials. You got to be really careful as you put those together, make sure that the franchisor and or the attorneys are looking at those, making sure that the audited financials are consistent with the FDDs and not creating problems for the franchisor down the road. You also got to be careful that the audited financials are not accidentally imposing new obligations on the franchisor. Sometimes accountants, when they're trying to put together these notes to the financial statements, use words that have legal meaning that they don't fully understand. So for example, I've seen a situation where an accountant referred to the fact that ad contributions by franchisees would be held in trust by the franchisor. Well, we want to be really careful that we're not creating a trust relationship, which under the law means that you've got a fiduciary relationship, a duty to put the other party's interests before your own. We don't want to create that obligation on the part of a franchisor. Another situation, for example, is where we'll see an auditor put in list of services that are going to be provided by the franchisor that might be different or broader than the services that the franchisor has to provide under the franchise agreement. What we don't want is an accidental document that comes in and creates additional contractual obligations for the franchisor. One thing that can be helpful when we review audits on behalf of clients is we can look at them and often tell when an impound or a fee deferral is going to be likely required in some or all of the registration states. So for example, a young or relatively small franchisor may be required under some of the registration states either to defer collection of the franchise fee until after the initial services are provided, or to put up some kind of an impound, a bond essentially, so that they can do business in the state, basically a guarantee that the franchisees will receive the services that the franchisor is promising to do in exchange for that initial franchise fee. So we can talk a little bit to our clients about, hey, is this something you're liable to have to worry about, and which states are you liable to have to worry about it? What kinds of things can you do to minimize the possibility of a fee deferral or an impound requirement? For example, the current ratio tends to be very important. We can look at the audited financials and determine what the current ratio, which is the current assets over the current liabilities, and determine whether, hey, you know what, this is something that's likely to be found eligible for an impound or a fee deferral. Sometimes there are assets in the current liabilities that don't necessarily need to be there because they're debts to an owner or another related party, and we can do things with the audited financials to make sure that we're minimizing the risk of problems down the road at some of those registration states. So I guess the takeaway is that the franchisor and the franchisor's counsel do need to understand those audited financials, not just stick them at the end of the FDD and hope for the best, but understand them, discuss them, make sure that they're protecting the franchisor, and if you can't avoid doing the FDD, at least set it up in a way that's going to protect the franchisor moving forward.